Somebody is murdered at work in California, and it turns out that the motivation for that murder occurred because of an extramarital affair. Typically, that would not be work-related, and there's case law supporting that. However, there's a recent case that came out that says there is industrial causation, and we're going to explain how the cases differ. Hi, my name is Michael Burgis. I'm a legal certified specialist in California workers' compensation. I'm a trial attorney, and I'm the managing attorney of MB&A. Typically, there's two burdens that you have to show to get that person workers' comp benefits, or rather get the dependents of the decedent benefits. And that is, you have to show that the death arose out of and was within the course of employment, what's called AOE and COE. So clearly, if this person's working and the murder occurred while they're at work during work hours and working, that was within the course of employment. That's usually not the issue. The issue, and how most defense attorneys and insurance companies can deny benefits properly, is if the death did not arise out of employment, but the motivation was completely outside, right? Dealing with the typical case you hear is there was a employee who was having an affair, their spouse found out about the affair, and then they came and killed their the cheating spouse at the place of business, right? And there's case law saying that's not work-related because it didn't arise out of employment, okay? Now, in this case, similar fact pattern, unfortunately, that the person who was murdered was having an extramarital affair, but the difference in this case was they were having an affair with a coworker. That is, somebody who was employed by the same employer at a different location, but with the same employer. And I think what the difference here really is that, you know, you can make an argument that had this person not been employed, had this person not met this person, coworker, in their employment context, that relationship wouldn't have formed. So even though the animosity and the motivation is for something that is not work-related in any way, shape, or form, but because there was sufficient context, and that but for this person being employed, they wouldn't have met this person, and that is the context that, you know, where the relationship arose out of, there was enough context there that this family was awarded death benefits because it was sufficient context that it arose out of employment. Now also remember that you take this fact pattern in something called Labor Code 3202. Labor Code 3202 says injury is to be liberally construed to benefit injured workers. So basically here, the AOEC burden was met, but it was met because the affair was a coworker. So this is just a reminder to anybody who's watching this that if you are ever in the situation where you've heard of or know of somebody and there was an unfortunate assault or murder that occurred at the workplace, but it's being denied because they're saying this is dealt with stuff outside of work, sometimes you can still link this. If you have any questions or concerns about this, our office is standing by. If you think this video has been helpful, please like and subscribe. We put out lots of content going all over the new case law, and it may be very helpful for you. And again, if you have any questions or concerns, we're here, we have the answers, and we're standing by.